Hi, this is Judge Dodell. We were talking about insurance claims because that's what I did for almost 40 years, going after insurance companies for either not paying claims, delaying payment claims, or for insurance bad faith. So we were talking about evaluating contents. Now, there will potentially be a dispute between you and your insurance company as to what it's worth. And interestingly enough, you may have an heirloom that you got from your grandmother, and it's irreplaceable to you in terms of its intrinsic value. Do you get what it's worth to you, or do you get fair market value? Fair market value is going to be a very, very small portion because you can probably buy whatever it is that you had, except you will not get the emotional payback for the loss. So what do you do first? The minute you have a claim, you need to report it. You report it to either your broker or your agent, and there's a difference. A broker basically works on their own. An agent works for the company or is licensed by the company as a manager. They're called managing agents. And sometimes you can call the insurance company directly. Your policy should have a contact number on it. Now, why is it important that you let them know right away? Because every policy has what's called the statute of limitations. In the policy, it's called suit against us. That's the general caption for it. It means you have a limited amount of time to sue the company if they don't pay your claim. And so you need to know how much time you have. Generally, it is a year. Some are 2. You need to look at the policies. I'm not giving anybody any legal advice, but the first thing you should do is read the policy, or have somebody who knows what it's all about read the policy. There is also a potential conflict of interest between you and your agent and broker. What if you thought you had something and you asked for something and it isn't in there anymore, or it was never in there, or they made a mistake? And this happens frequently. In fact, I wrote an article called Liability of Insurance Agents and Brokers a number of years ago. So you really need an outside third person who has no interest in the outcome to review your policy and give you an explanation. I had a case many years ago, up north actually, near San Francisco, where they went and actually counted all the pencils. They were really, really difficult. And if you end up in a disagreement, what do? Do you have to sue? No. There's a procedure in California called an appraisal procedure. It's under Section 2071 of the Insurance Code in California, which says if you and the insurer disagree as to value, not to cause and not to anything relating to liability, but just on value, whether it's a building, whether it's contents, whether it's additional living expenses, which I'm going to talk about next, you have what's right. You have the right to have an appraisal. In fact, in my book, which is called From the Trench to the Bench, I have a copy of an article I wrote on appraisals for Los Angeles Lawyer magazine back in 2002. This will tell you all about the procedures. How do you do it? You appoint an appraiser. They appoint an appraiser. The 2 of the appraisers get together and they nominate somebody called an umpire, and takes 2 out of 3 to determine the value, and it is binding. In fact, those awards are almost always approved by the court and can become a judgment against an insurance company if they don't pay it. So go to eBay, look for comparable sources for fair market value. You can certainly find out what replacement cost is. Use your videos, use pictures. I once got a claim paid on a ring because we had a picture of the insured sitting at a dining room table, and you could see the ring clearly on her finger. So next week we'll talk about additional living expenses, and we'll talk to you then.